Hello, my name is Brandon Davies. I'm a criminal defense lawyer based out of Overland Park, Kansas. Now in this video, I'm going to be talking about the administrative side or the administrative case in a DUI context. Now when you get a DUI, you essentially get two cases. You get the criminal case. That's the case that most people come see me on. The part where they know that they're in some sort of trouble, they're worried about possibly going to jail or possibly having a criminal record. That's the criminal case. The other side of the case, the more lesser known case, is the administrative case. What the administrative case is the state suing you, trying to take your driving privileges away. Now the administrative case is keyed off whenever an officer arrests you for a DUI and they take your driver's license. They're going to mail in a DC-27 form, or a notice of temporary license suspension, along with your driver's license to the state. From the day that you get that DC-27, the date that it's served on you, you have 14 days to start or to at least appeal, say you want to have an administrative hearing on your license. If you miss that 14-day timeline, you will automatically lose your driver's license, almost certainly. If you do file your notice to appeal, you file your notice to contest the fact that you had this DUI suspension or you do not want to get your driver's license suspended, that's where the case begins. Now, when you're looking at a DUI case, you have to understand there are two different types or two different burdens of proof depending on what side of the case you're on. On the criminal side, it's a high burden of proof. Beyond any reasonable doubt, this prosecuting agency has to prove that every single element of the case, beyond any reasonable doubt, that you did it. On the administrative case, the burden of proof is a more likely than not standard. In other words, it's just slightly above 50%. And actually, you have the burden of proof. Whenever you go into the administrative side of the case, you essentially have to prove that you were not impaired to a level you're unsafe to operate. Now that can be very difficult. It can be very difficult because you're going to have an officer coming into the administrative case saying, I saw that person, they exhibited these behaviors of a person that was impaired, and there may be a breath test result that the officer will have. So it's a very difficult side of the case to win. Well, this happens very often. People come into my office and say, well, Mr. Davies, I was drunk. I did violate the law. Why do I want to have this administrative case if it is going to be a very difficult thing to win? That's a good question. The reason that you want to have your administrative case is it's your only way to contest the fact that you're going to lose your driver's license. And the administrative case doesn't have to be a open and shut type case. What your lawyer's going to do is look at the DC-27. They're going to look at the protocols on the 9000 to see if they observe those. They're going to look at the case after they've received discovery and try to contest the facts or save your license. Even if your lawyer can't save your license or the facts are situated in a way that you're going to have a very difficult time, it still benefits you to have your administrative hearing. Here's why. Well, if you look on your DC-27, it's going to tell you your license will automatically be suspended after 30 days of receiving that notice unless you appeal or unless you file for administrative hearing. If you do that, then you're going to get some documents from the Kansas Department of Revenue that you're going to be able to keep with your DC-27 and extend your driving privileges past that 30 days. In fact, you're going to be able to have your driving privileges until you have your administrative hearing, which can be set 2 or 3 months from the time you get the DUI. Even if you go on your administrative hearing and you lose your administrative hearing, you're going to get another 30 days so that you can continue to legally drive. Now, those 3 or 4 months of being able to legally drive can be critical. It can help you get a plan in place for what's going to happen in case you do lose your license. Now, the administrative process is the only way to contest the fact, only way to try to keep your driver's license. It's a very important part of the DUI process. It's a very complicated area of your case. If you have any questions about your administrative hearing, administrative suspensions, or anything associated with the administrative side of your DUI case, you need to sit down with an experienced criminal defense lawyer, go over the facts of your case, go over discovery, and have them give you an evaluation as to your chances of keeping your driver's license. If you have any questions, feel free to contact my office at 913-451-9500.